We're going to call the meeting to order, please. I want to thank everybody for their patience this afternoon. It's been a long day. Appreciate everybody's patience. At this time, I'm going to recognize Vice Chairman Leverett to present the bill, speak on Senate Bill 68, the committee sub, and Chairman Leverett. You got it.
I have to push that on. Is it? Okay. Thank you, Mr. Chairman. Ladies and gentlemen, I have a substitute to Senate Bill 68, which was just passed out of the subcommittee. It's LC 492362S, and it should have been handed out to you, and you should have it. I'm sorry?
Yeah, they got it.
Okay, you've got that. So what I thought I would do, this of course is the lawsuit reform or tort reform legislation that's came out of the Senate. That's the governor's legislation, and we've made a number of changes to it in committee. What I thought I would do is, assuming folks are generally familiar with the bill, I will go through and discuss the things that are different in this sub compared to the bill as it passed the Senate, but I'll also try to describe what each section generally is. So. Starting with the bill on pages 2 and 3, section 1 has to do with the concept of anchoring. That's where an attorney might mention early in the trial, before any evidence is in, what non-economic damages, those are things that are not out-of-pocket expenses or measured by some bill, what those would be in the case. And this generally prohibits mentioning that until all the evidence is in and you're arguing to the jury. On page 3, there in lines 45 through 50, we tried to clarify, because in closing argument, the plaintiff generally gets to have an initial closing, and then the defendant argues, and then the plaintiff gets a rebuttal. So there's an opening and concluding argument for the plaintiff most of the time. And we just tried to clarify that if you argue in your opening argument at the close of the case, you can also argue in the concluding argument the worth or monetary value of economic damages. But you have to be consistent. You can't sort of sandbag the opponent by saying one thing at the beginning and then saying something else in the second closing that you have. We also added in lines 55 through 58 a section that just says you can ask when you're questioning potential jurors as to their capacity or qualification to sit on the case, you can ask them if they could return a verdict that doesn't award any damages. That would be a defense verdict if the evidence supports it, or if they could return if there's a number beyond which they couldn't go even if the evidence supports it in terms of damages. That's something we have received some correspondence and heard from. That's a question you usually like to ask in a case, and so we were able to preserve the right to do that, just to clarify that can still be done. The next change is on the top of page 5 in section 2. This has to do with when you can file when you file an answer, and more specifically the impact of a motion to dismiss. So there's a provision about a motion for more definite statements, some other things that try to deal with that process and procedure. The main thing here that's gotten a lot of attention is if you file a motion to dismiss, there's a stay of discovery. Currently it's for 90 days. The bill would change that so the stay would be in effect until the court finally rules. And we changed that so that the 90 days runs from the conclusion of briefing. That is, not just when the motion is filed, but when the parties have submitted their briefs. And those changes are in lines 93 and 98. But because of the concern that sometimes the courts don't rule within 90 days, we added that there's a provision already in there that said the court can terminate or modify that stay, but if you can't get the judge's attention, you could utilize any other remedy, such as a suit for mandamus or anything else that might be available to get the court to rule so you could get a decision. Section 3 is on voluntary dismissal. Currently, you can dismiss a lawsuit up until, I think, the first witness is sworn. That's viewed as to be pretty late in the process. Initially, it was to be moved by the original version of Senate Bill 68 was to move back to when an answer is filed. They since changed that to it would be the 60th day after the opposing party serves an answer, and we've just kept that, although there was a provision in there about if you could file a motion if the defendant filed a motion for summary judgment, that would also trigger the 60 days. The motion for summary judgment came out. Section 4 concerns a double recovery of attorney's fees. It generally prohibits that because it has happened in some cases because they're different statutory bases for recovering attorney's fees. This just makes it clear you can't do that, and we didn't make any changes there. Section 5 changes the rule about seatbelts. Generally, right now, whether or not you were wearing a seatbelt is not admissible, even if you're suing for injuries you sustained in an accident where you were not wearing a seatbelt. The bill would change that rule so that it is permissive. The court can allow that evidence in, and that is, the word may is used in 161 and down in 164. So the court doesn't have to let it in, but it would be able to, and we just added to the bottom of that page to further elaborate on the fact.
Mr. Chairman, I think a few folks may be missing some pages. Chairman Leverett, at least ours jumps from 5 to 8, and I think it's a printing error because the 1s and 2s show the total sections. Does any of y'all's do that?
Yes, mine jumps from 5 to 8 as well.
Rooms 5 to 8? Okay. So just tracking that so you can
Okay. All right, so right now I'm about to leave 7, and I'll be back on page 8. I don't know, Mr. Chairman, if we want to redistribute that or if I should just continue.
We need to get those printed forms.
I would think folks might want to see it.
Hold up a minute. We're going to get a little printing done. Is there any objection to proceeding with the copies that we have, and we can, if somebody doesn't have one, we can get them one? Okay, let's go ahead. Go ahead,
Okay.
Chairman.
So down at the bottom of page 7, it's on lines 165 through 168. That language is new. It just makes it clear that the court can still determine whether or not the evidence is admissible based on whatever the applicable, relevance and materiality and prejudice and all that sort of thing. So not really a substantive change. It's just kind of confirming the way that statute would now work. All right, in section 6, this is the premises liability section, which is the longest part of the bill. We made a few changes on page 8 there. There had been a phrase in line 179, an except is provided in subparagraph B, that was from an earlier draft and did not make any sense any longer, so we struck that. And then down on line 184, we revised that section to try to make sure this was just focused on premises liability, because there was some concern that the way the language had been drafted earlier, it would take in other sorts of claims, like involving injury to student at a daycare or injury to someone who's in a nursing home or something like that, where there was an employee doing something. So we've just limited here. It's not just keep persons on or around premises safe. It's just to keep the premises and approaches safe from the wrongful conduct of third persons. Then also along that same line, we tried to tighten the definition of third person up. That's on page 9 on line 212. It previously was just anybody other than an owner or occupier, but we've also added it's also anyone other than somebody who's under the direction, control, or supervision of an owner or occupier. In other words, if the third person who causes the damage is the employee of the owner, the analysis in this statute would not apply, because that's a different kind of claim. It's not a premises liability claim. On page 10, we made a few changes there in lines 227 through 238. The bill previously required that all 3 of those elements be proven by clear and convincing evidence, which is a very high standard. We removed that so that it applies only to down in lines 235 and 236, whether the owner-occupier knew or should have known by clear and convincing evidence that the third person was or would be upon the premises. We did change knew in lines 230, 233 to had actual knowledge, which I think was the intention of that word. It was to make it clear. Then on page 12, there was an existing exception for claims for human trafficking. This is up in lines 275, 277. We changed that in two ways. First of all, we added on line 275, or otherwise affect, so it shall not be construed to limit or otherwise affect, because the otherwise affect appeared just below there, and there was a concern that it might cause some differentiation in the way it would operate. And then instead of just limiting it to a cause of action brought pursuant to Code Section 51.156, which is the civil cause of action for human trafficking, we added or any other applicable law or theory of recovery otherwise recognized by law, including but not limited to negligence and nuisance. And that was based on testimony we heard from some practitioners in this area who were asking us to make that a little clearer and a little broader. So we did that just to try to protect those victims. Then I think the next change, Mr. Chairman, is in Section 8. That's the bifurcation section. So that's the section that basically provides if you're trying a case, one party can demand that the liability be tried separately from the compensatory damages, and that also be tried separately from punitives. Currently, the law generally requires punitives to be tried separately, but this would also add the ability to bifurcate liability and compensatory damages. Well, we tried to clarify what we understood the intent was. On page 18, in lines 423, 424, we added that the trial would be recommenced, and then we added immediately with the same judge and jury, and we added the same thing down in lines 428 and 429 if you have to go into a punitive phase. The idea being trying to make it clear that this is not like you would have your liability phase and then come back in 6 months and try damages and come back in 6 months and try punitives. You try it all as one proceeding. You just have phases to that proceeding. And then we added in lines 434 through 441 some exceptions. So that the court is given authority to reject an election to bifurcate the trial if the court determines that the plaintiff, or if the plaintiff is a legal guardian of a minor, the minor is suing over some alleged sexual offense. That would include trafficking. It can include other sexual offenses as well, and would be likely to suffer serious psychological or emotional distress as a result of testifying more than once in a bifurcated proceeding. So that's one exception. And the second one is just really a smaller case exception if the amount in controversy is less than $150,000. So that section B was not in the bill previously, and it has been added to just sort of allow courts a little discretion to deal with bifurcation. So that is the substitute, Mr. Chairman. I'm glad to answer any questions.
Okay, okay, you've heard the explanation by Chairman Leverett. Are there any questions for him? Yes, sir.
Mr. Chairman, at the appropriate time, I'd like to make a motion.
Okay, hold on just a minute. We got a question. Representative Hughley, is that you that has a question?
Thank you, Mr. Chair. I know the lawyers have lawyered this bill pretty good, but on line 447, why are we, is this an attempt to make this retroactive to things that are pending? Is that something that we generally do?
I can't really say whether we customarily do that with respect to changes in procedure. Generally, the changes in procedure usually become effective right away. To the extent it would be unconstitutional to apply it to an existing case, though there is an exception specifically addressing that, and that'll be up to the courts to decide in every case. So, I mean, I acknowledge that question. I think that's a good question, but the way the bill is drafted, it does become effective as to the procedural aspects, like the Civil Practice Act pieces. 6 and 7 would apply only to causes of action that accrue after the effective date of the act.
I've been around a little while, and isn't it true that we generally don't try and make whatever it is we do retroactive? And you say in here, unless such application would be unconstitutional. So in our effort to reform tort, are we inviting other causes of action?
Well, I suspect we're inviting litigation, yes, ma'am. I think that's likely to happen. But, and the lady has a distinguished record of service here, so I can't speak to the lady's experience. I do think, in my experience, we try not to apply substantive rules that would change the outcome of pending cases. I don't think we observe the same rule with respect to procedural ones. And so I believe that's what we are doing here. To the extent the lady feels that we should have it applied at a later date, I acknowledge that concern. I just think that's not viewed to be the appropriate policy at this point.
Thank you, Ms.
Whip Burchett. James,
No, I don't have a question.
did you have a motion?
I do have a move to pass.
Okay, we have a motion, and Chairman Hatchett seconds. Now, is there any other discussion? There is discussion. Representative Evans.
Thank you, Mr. Chairman. I just wanted to speak to the proposed amendments at the appropriate time.
Yep, okay, now is the appropriate time.
Thank you, Mr. Chairman. And I recognize that our subcommittee meeting went long and we moved the same amendments in subcommittee, so I won't do the longer explanation that I did in subcommittee, trying to, win friends and influence people here. So I'm going to go a little quicker, but I do want to touch on a few points because I do think it's important for the larger group. So I'm just going to talk about a couple of the sections. The amendments generally are meant to actually bring the balance back that Senate Bill 68 says is its aim. So in Section 2, the amendments are aimed at trying to make sure that we don't have claims languishing forever and plaintiffs with great claims dying simply because of the passage of time, when they can't get access to care, when memories fade, and when documents disappear over time because of the unlimited stay. And it is not atypical in this state because of our overworked courts that you have motions to dismiss languishing for 1 year, 2 year, 3 years. That's just simply not unusual. And this is going to have an unlimited stay and is going to keep plaintiffs from being able to get access to the discovery that they need. So the amendment would put an end to that stay and allow a defendant to move to keep it on if necessary. The other specific part I want to address is related to negligent security. As the bill is written, the substitute as amended still requires that there be a defect in a physical condition on a property before you can have a negligent security case. So this means that under the sub that we're being asked to vote on today without amendments, the owner could have all the knowledge in the world, all the foreseeability that we are now going to require under Senate Bill 68, that there are knife fights, that there are gun fights, that there are rapes. But if those are not connected to a physical defect, like a busted out light, a broken gate, or a lock malfunction, there is going to be no claim because you have to have both. You have to have foreseeability of crime, and that crime has to be connected to a physical defect. So the amendments that are before you would fix that. Also in the same Section 6, while I really appreciate the extra care provided toward victims of sex trafficking, I just cannot justify in my mind how I look a victim of a child who's been raped in a stairwell or someone whose child has been killed and explain why we're treating them differently. And I think the Constitution will have that same question for us. And so the amendment would address that to make sure that we're treating all crime victims equally. Section 7 attempts to bring fairness to those who do what we ask them to do and have insurance and not punish them for that. Section 8 attempts to bring fairness to victims to not have to testify twice regardless of the type of victim they are, sex crime or otherwise, and also to respect our courts and their discretion to decide when a case should be bifurcated. And then the last thing I want to highlight, and it follows up on what Leader Hughley raised, Section 9 has an effective date for all of this new procedure, which is major. We're creating new sections. We are changing the way discovery works. We are changing the way answers work. And I know this is boring for the non-lawyers, but I'm just nerding out here for a second. We are creating a potential confusion nightmare for our court system by having all these procedural things go into effect to cases that are pending right now. You could have a case that's in the middle of discovery, but yet a motion to dismiss is pending. What happens? All of that work, all of that effort to move a case forward just ends because of Section 9. You could have a case that's in the middle of a trial that's not bifurcated, that now a judge has to figure out what to do. Do they have to start over, for example? So we are creating inefficiencies. We are creating more litigation that's been acknowledged here in an effort to pass a bill that we're told is to cut down on lawsuits. And so that's what the amendment in Section 9 attempts to address. And I'm happy to answer any other questions about the amendments, but otherwise I move those for your consideration.
Okay. Are you moving on those amendments now?
Yes, Mr. Chairman.
Okay, we have a motion. Is there a second on her amendments? There's a motion and a second. All those in favor of adopting the Evans amendments will say yes. All those opposed will say no. All those in favor say yes. Yes. All those opposed say no. No. Motion fails. Okay. Now, we have a motion that we do pass by substitute LC 492362S, and there is a second. All those in favor of adopting this Senate Bill 68 by substitute say aye. Aye. Any opposed? No. The ayes have it. Okay, and that will be available on rules on Thursday. Mr. Powell, I know that this is not going to make you happy, but we're not going to meet tomorrow at 6 a.m. when you're up attending the Senate meeting. So if you just go ahead and meet with them at 6, we won't be there with you, okay? I want to thank the members of the subcommittee and the members of this committee for your patience as we've gone through this process. Thank you all very much. We're adjourned.